All the paperwork we had at the time said that it was a 200 by 200 lot. I had not bought the lot at that time. My wife had bought it with an ex-husband. It was a 200 by 200, and for 20 some years had been paying on this lot. We didn't see any notations of difference. She did not have the abstract at the time. So I had called out for an abstract replacement through my bank, and attorney in Chatfield was doing that. I did not receive the abstract until July 23rd of 2019. And at that time, I was a month out from having to get my stuff out of the building in town. So I set it aside and quickly continued on. 2 weeks prior to moving in, Mr. Kaler showed up and said that he owned the East 66 feet, and there's where the problem started. Started looking into it, could not find any documentation or any application for a variance process to divide it off in conjunction with your section 15 of your subdivision standards. At that time, Winona County Planning and Zoning gave me a permit to build the building. I completed the building and moved the assets, even though it was an argument because if I didn't move out of the building that I vacated in town, I would have lost the assets. So I had to move all the assets out. I didn't have an option of any place to put them. So I had to move them. In preparation for finding this land, I had wished to build a bigger building though, and I had called Mr. Kaler on 3 separate occasions, starting in November of 2018, asking if I could buy a acre and a half field to the north of me, which you saw in the pictures that's over that hill. Not a reasonable offer was made, so I could not afford it. I had limited values of money to work with. So I asked about extending the lot. At my understanding was a 200 by 200. I didn't ask for any certain size. I just figured I was extending my lot up to what was the cemetery where Mr. Johnson took the pictures from the highway at. Another unreasonable number came back. I couldn't afford it, so I just decided to work with Blakely and build the lot that I could, or build the shed I could on the lot I had. After completion of this, excuse me. After completion of this building, I moved in, got all my stuff out of the building in town as I had to, as the agreement was there. Didn't have any other choices where to put the stuff. I wasn't broke, but I don't have any money to go out and buy another lot and put up another building at this time. Through the courts and the process, I've been ordered to remove the building from the overhang. I don't believe it's right, but I can't argue. It's what I need to do. So the building is plumb full of assets that I'm using yet in my electrical career, and I would like to save as much of the buildings I could to keep the assets in there. I've already had to start selling some to prepare for this. It's assets I would use yet in my career, but I've had to sell them and do other avenues to make it work. Through the mediation ceremony sessions, though, I had found other ways that Mr. Kaler could get into property. I could have got him a driveway off from 74 over where the picture was taken by that white fiberglass fence. I could have got a driveway and proposed offering that in. I proposed to buy the lot back from Mr. Kaler that this 66 feet was on. Offered many solutions, couldn't come to any reasonable one. So that's why I'm here today asking you if you would give me the opportunity to have a reduced setback and move forward that way. That's all I have unless you have questions.
Okay, do any of you have questions? I have one question is with that door, if the shed is reduced, does that door stay there? Can you use, okay.
No, it's all got to come out.
Yep.
Because you saw a big white trailer there, that's a trailer I use every day, or
Yeah.
I can't say every day,
But yeah,
but I could not, through the mediation, take his offer of, here, I'll build you a little tiny driveway. That trailer takes a little bit to get around, so that's why I would like to build a new driveway that I can control how I can turn and the width of it.
Yeah.
I just, if I don't have a certain width driveway that I can maneuver it into the building,
Yeah,
I got to park it on the road or I'm out of business. So that's why I'm asking for a separate driveway.
is, just as a technical thing, does the roof overhang, or won't you have a roof overhang?
No, sir.
It'll be flush.
Can we go back to those pictures or
In-
may I?
I'm just curious as to
Oh,
what.
I'm sorry. It's right in front of me. He started looking at me anyways. The one that shows that east end. But yeah, so this east end here beside the trailer,
Yeah.
the overhang on the south will remain. It'll get pushed back and it'll be just a square roof cap on that east end, or yeah, on the east end.
Mhm.
The other thing I have to, can I go point?
Yes, go ahead, yes.
Behind this trailer, there's an LP tank, my electrical, everything came up here was designed for entry on this end of the building. So what I'm gonna have to do is, when I push the building back, I'll dig by in the that 1 foot overhang and go around to the back of the building to put my electrical service. Also, I will also, would ask for that 1 foot setback on the east side to be allowed to come around the north side a little bit, because I have to set the LP tanks up on some cement pillars to keep them away from the building. This is a temporary setting, and the LP guy said you need to move 15 feet, 10, 15 feet from the building.
Okay.
Get it away from the building like he's asking, I need to set it away. And this was under argument before we even got it finished. So he allowed me to leave the tank there, but it needs to be moved out, and I have nowhere in front to move it to or west to move it to.
Yeah. How far is the line from the back of the building?
There's probably about 15 feet there, because the well,
Yeah, so you need, yeah, so with the
Can-
tank, you need,
because can I see if I can find it here quick? Maybe the other way here.
I don't know if there's necessarily a setback for LP, I mean, from the building, but from the line. Do you know, Eric?
LP is considered essential services.
Yeah.
There's technically no setback other than
Yeah.
the
Or whatever, safety, yeah.
fire code.
Right.
Right, so this is the wellhead here. I had to keep the building moved far enough ahead so that the well guys could get up there. And here's the lot line. So in this gap, there's about, I think it's 12 feet, something like that. I'm gonna have it
Right, yeah.
resurveyed if this is approved. I need to know exactly where the marks are at. So I would set the LP tanks up here. That way I can have the well guys drive in from the other end if I need
Yeah,
to.
right.
And then can also get the antenna off from the house too and set it in the ground right there. So it's just cement pillars that, for the utilities is what I'm asking for.
You have anybody else? Do you have any more questions? If not, thank you, Noble.
I would like
Do you have
to,
any more to say?
no, I'd like to reserve the right to come back and answer questions
Yes,
if the other parts come in where I need
Right.
to.
yes.
Okay, thank
You
you.
can do that. Okay, and let's see here. And actually, just to, I don't know if it's required to make it official, but we did not read publicly the petition. I'm going to read it now as soon as I find it. And where is it actually in the agenda? The petition number is, as I stated, and it's from Noble and Denise Salisbury to the consideration of a variance to allow 1 foot setback from a property line and an existing structure instead of the required 8 feet within the urban residential zoning district pursuant to chapter 10.6.6, parentheses 3 of the Winona County zoning ordinance. And amended to include the findings of fact on page 18. So I would entertain a motion to open it to the
I
public.
will make a motion to open the public hearing.
Second.
Okay, the motion was made by Jordan and seconded by Kelsey to open the meeting to the public. All those in favor say aye.
Aye.
All those opposed say nay. The meeting is now open to the public. Is there anyone else who wishes to address this? Please come forward and state your name and address for the record.
I'm Ed Kaler. My address is 203 County Road 7 Southeast Eota, Minnesota. I own the farmland and the 66 feet that's in question in this petition. I have a couple portions of the packet that I segregated out to hand to you to discuss. Yep.
For this one copy.
Here, no, I got three. I was giving you that one.
Are these different from what we have or?
Well, they're just individual pages I'm going to refer to.
Okay, all right. Mine.
Copy, I'll need a copy for the record.
Okay, I wish to thank you guys for being on this board. I was on the board in Olmsted County, and so I know the stress you go through sometimes. Okay, I'm looking at this variance that they have here, or they're requiring. The variance request is in harmony and intent and purpose of the ordinance. It is not identified below in that the variance request is consistent with the comprehensive plan. It is not consistent with the comp plan. It's a commercial building misrepresented as a residential building on the application, along with being a building that is knowingly built on land Mr. Salisbury did not own. And if you look on these pages that are in this packet I gave you, you can see the deed that he was given, that Denise Boyum and her husband were given when I sold the property to them, which was in 2000. It excludes the 66 feet. After an extensive process, we started the process actually in the fall of 2018. Mr. Salisbury did call me, and I did return the call to him, and he asked about the property to the north. I did give him a price on the property to the north, and he told me he was going to take it to the town board to get it rezoned if he could to a commercial property, because he needed commercial to put his commercial building up. I never heard back from Mr. Salisbury after I gave him a price. So I assumed he did not want it. About the middle of February, I called him and asked him, and there was no return of his call to me if he was interested. As you can see on the sheet in the back of my packet, on the Exhibit 8, I plan to use this 66 feet for a road to the property to the north to build a residential development at some future date. That's why it was excluded from this property when we sold it. And I drew some lines with a middle line of a property of a road going up through there. With the dotted lines, the edge of the road, the solid lines, the 66 feet of the property. And I included in there how his new driveway that he's proposing, which is fine, except for the fact it should be set 8 feet away from the property line so that it's not in violation with the current ordinances. If you did that, he wouldn't need the proposed water from the shed to go across my property, which creates another issue down the road. He could run the water through a tile line on the end of his property if he wanted, or he's taking the shed down anyhow. Why wouldn't he take it down 8 feet from the property line so that it's not in violation? an extra 8 feet to take off the shed is not any extra cost to him. And then he would be able to run the water on his own property. The road being built in there will need to have setbacks. So if there are setbacks, I would like to have the variance noted that I will not be liable for setbacks from his property of 8 feet if I decide to build the road of an additional 8 feet to make it. The granting of this variance needs to ensure that my rights and options of my property will not be diminished due to the variance. The applicant has established there's a practical difficulties in complying with the official control and progress purposes of the property in a reasonable manner. There is no practical difficulties since the building will be removed anyway. Mr. Salisbury is running an electrical business, which is a commercial out of a residential lot, and this is not a reasonable, and the property is not zoned for it. And then the use was misrepresented on the applicant to build and the variance applicant. The variance request is due to special conditions unique to the property, not created by the owners or the property since the easement of this ordinance. Mr. Salisbury totally created this problem, knowingly building too large a building on property he didn't own. The deed clearly spells out the property boundaries when purchased by Mrs. Salisbury and her ex-husband. Mr. Salisbury tried to buy the land pre-construction, showing he did know the land was not part of his. The court ruled on this question 100% in my favor. There's nothing unique about the lot and the block. He simply needed to build a smaller building. The variance will not alter the essential character of the locality and substantially impair the property values or public health and safety welfare in the vicinity. That's number 5. No one wants to live near a large commercial building in a residential neighborhood. I have attached an expanded view on page 21. My ability to develop the property above the access road could be compromised or decreased distance from the property line and the proposed flow, Mr. Salisbury, of water that Mr. Salisbury is requesting.
It's on. Tune into it.
Pardon?
Go to Winona County Adjustment Board.
Who's speaking?
Not me.
Oh, go ahead.
Oh,
Go ahead.
okay.
Go ahead, Ed. I don't know what came in. Go ahead, Ed.
Okay. The economic considerations alone do not constitute a practical difficulty. The only issue is the economic consideration of removing his building further back, which would cost more. The variance, on number 7, the variance cannot be alleviated by a reasonable method other than the variance of the minimum variance, which would allow the practical difficulty. A portion of the building has been ordered removed by a court judgment. The variance is requesting not to remove as much as required by the judgment due to economic advantages of space and removal costs, both which are already going to occur with or without the variance. The request is not a use variance and shall not have an effect of allowing any use that is not allowed in the zoning district. Permit a lower degree of flood protection than the regulatory flow protection evaluation or permit standard lower. The request is a use variance. Mr. Salisbury is requesting a commercial building in a residential zoning. which is not allowed. His application lists residential, yet in his letter, it states moving his business site from a commercial property that he was renting. His proposal has all the water of his property being drained across the road onto my property. This is not proper and will add additional problems for my property, which is a future development of property the road provides access. Also, we've already remedied this problem for the county in our arbitration agreement, which was signed by Mr. Salisbury, Mrs. Salisbury, and myself. It states that the building, I granted them permission to leave the building there for 15 years. And at the end of 15 years, they had to remove it 100% off my property and comply with the zoning ordinance in the county. So, I mean, he's already agreed to this agreement. And when you look at the property where the existing road goes, I don't know how to run this. Can you go to the, shows his white trailer on the east end of the building? Okay, this picture right here, part of our arbitration agreement is he has to bring all of this back up to this line here on the property coming down as it was existing before he dug it all out and removed all the dirt. So when he puts that back in, which he still is required to, even if you grant this, his water won't flow the direction he's asking for it to flow anyhow. It just won't flow that way. And so anyhow, that's, the other thing is, I do not think he needs to be granted a foot or variance on the north side of the building, as there is no setback requirements for a LP tank in the ordinance, as was just stated by the county planner, other than maybe a fire code or whatever, which he does have room. He could run a line off the east side of the building if he wished, or off the west side of the building if he wished to. As far as his new driveway, that should be set back. If he builds a new driveway, it should be set 8 feet from the property line as required by county ordinance. And that would, alleviate the problem for his drainage, in that he could drain the water down that 8 feet of the ditch to the bottom of the road where it joins Don Drive, as seen by this culvert. Right side of or left side of the picture there. So, any questions?
Do you have any questions for him?
So on this one where road's getting taken out, where it
Can I
currently
come up there and look
is.
at which one you're pointing to?
Yeah, I have this one.
Yeah.
So where this is getting taken out,
That
is
road
this
is-
part is staying because the culvert is there? Is
Well,
that?
this is my access to this field in the
Oh,
north.
so you're still gonna use that one?
Yes.
Okay,
And
all
this part up here was what I was telling about, has to be all filled in.
Mhm.
Next to the building, okay?
Get into the field, and it's to be built back to the natural slope of the house on the east side here, which this house here, according to our agreed arbitration agreement.
Mhm. Any other questions? If not, thank you.
Thank you for listening today.
Yes. Eric, you may approach the microphone.
Just feel compelled to comment on a couple things, just so the board has correct information. In the UR district, structures are the applicable feature that requires setbacks, like
Yeah,
buildings.
okay, yeah.
Driveways, there is not setbacks from property lines or amenities such as gas and electric and propane and things of that nature. Septic and wells, they have their own code. Yes, we do have some things in play with that. That's a private property. That strip is, if it was a public road such as Don Drive, public thoroughfares require a 65-foot setback from the center line for all structures. So even if that was a public road, there would be a lot of problems because you cannot meet a 65-foot setback
Yeah.
from the center line of it,
What
so.
about the commercial building in that area?
Commercial, it was applied for, it's a residential structure for, as the applicant has mentioned, for his business activities. But if he was to run a business, if he was to hang signs, have employees, then it would be potentially a home occupation where it isn't a residential district, but that is a separate process. They would have to obtain an interim use permit or a conditional use permit to operate a business. But as far as what the assessors and what the planning had looked at and issued, it's an accessory structure in a residential district.
Okay.
So as long as he's just storing the stuff there, but nobody's coming on there for consultations or he's actually doing the work there. it's
Correct. If
stored there.
it's leaving off work or off site for business purposes, yes, it's for, as he mentioned, for his storage of his materials.
And as far as the septic system drainage goes, I see a couple of are those trees? I'm just wondering, he's got on this one that there's gonna be a water thing going over the driveway for the rainwater catchment off the building. But if you move the driveway over, I mean, can you do that? Or is it a matter of like, there's already stuff there, like the septic drainage that would affect where the driveway goes? Or in
There's a
terms of the
septic
setback?
tank in the drain field was installed in that portion of the yard, so they do have to be careful not to flood that area out with additional drainage. But they do have to be cognizant of where the drainage is coming off of rooftops and stormwater and around the parking area.
And I guess I would also, can the driveway get moved over 8 feet, or is that in the way of?
They would have to do their homework on that. There'd have to be some plans because we would not allow a new driveway to go over the top of the drain field that's there for the septic system.
Is there any limit to the height or size of commercial buildings other than the setbacks? I mean, I should say.
35 feet is the height limitation on a structure. Also, we heard some discussion about the rear yard property line. In the UR, there's a 15-foot rear yard property line, and that would be the so-called northern property line on this parcel. And that's currently being met from
Okay.
all accounts.
Okay. Any questions for Eric?
Is it possible to put a public street on the 60-foot, 66-foot pencil in the first place?
I'll keep a couple of brief comments on it. That action would have required an amendment to that subdivision plat. That should, to do something like that, to alter a subdivision, to start messing with a platted subdivision, it should have went through the township, through the planning commission, and through the county board to do that. When that subdivision was approved in those lots, everybody has expectation on how many lots are there, what is buildable. Essentially, they're almost turnkey for getting permits once it's gone through the platting process. To kind of arbitrarily start dividing that up, that's taboo to do that. That requires a formal process, and I touched on that in the staff report, so.
Okay. All right, thank you, Eric. Is there anyone else who wishes to address?
Yes, I'm Ralph Kaler,
Okay,
Eota, Minnesota. Ed is my brother. Yeah, I do want to address, this is a variance, not a conditional use permit. I think in the findings of facts, we have shown that of the 8 conditions, this property does not meet all of them, this variance request. Quite simply, it comes down to when you build on someone else's land, you don't get to make the rules. That's the plain and simple. In your item number, page 49 or 43, Mr. Salisbury talks about meeting with my brother to try to buy the land. If we look at, in his letter, he talks about having an abstract and not getting to do it. But yet the deed that his wife signed when they purchased the property, it's attached in there for item number, page 72, but in the packet, you can see it's highlighted. The 66 feet are excluded from the property. This was signed back in, what was the purchase? I believe August of 2000. So the changes on this, it's a recorded deed, pre-conditions. Now, if we change that driveway now, there may be some conditions, but at the time, recorded in the deed and that property and that land was taken out, we can go back and check, but the rules were different at that time and the requirement and the things that were required. But essentially, this is a land use rights. When you build on someone else's land that you don't own, and you had a conversation before you built the shed, I feel bad for him that he was cramped for time. That's not our problem. He went to buy the land and didn't like the price. Fortunately, that's not my brother's obligation to satisfy that. He gets to decide what he wants to ask for the land. It's also his decision whether he sells it or not. And I believe it should be his decision whether someone builds on that land or not. Not the neighbor who said, well, I talked to you about buying the land. I didn't like the price. I didn't buy it. I started building a shed. You told me it was on your land. I was going to go to court. I built it anyway. And now that I got to take my shed down, it's really an inconvenience for me. I don't think that's the way our plans are set up to be. I don't believe that's why variants are granted, to make it okay. If that's okay, do we get to build on his land if we need to? Do we get to move that driveway over and run maybe around the backside of his house because it's more convenient? Have to decide what kind of precedents we're going to set when someone didn't follow the law and built on someone else's land.
Okay, thank you.
Thank you.
Does anyone else wish to address this topic? If not, I would entertain a motion. Oh, is there, okay. Okay, yes, you may come. Yep.
I'm sorry. Noble again. Sorry, they're going to be a little bit random because I was taking notes as they were going through this.
Okay,
The commercial part of it. I spoke with Mr. Blakely, who gave me the permit. And we talked about the business had no employees. He said I could have up to 1 employee and still have it in my residential garage. It's a storage facility where parts get dropped off and I pick them up and take them out. No work's done there. Nothing is built or done in that facility. When we talked about a precedence for how this should go, can I get that clicker back? I'd like to get. We're one of them. Do you have the packet that I supplied for the permits for this with my drawings?
2 drawings.
Oh.
You could ask them to refer to their packet that they have in their books too.
Oh, okay.
Because they had your complete packet that's in their reference, but I do have these 2 images.
Okay. So it would be,
page number.
sorry, I thought we had it all up here.
No, that's okay.
Let me find it.
Take your time.
When I applied,
Which, are you looking for?
I'm in, okay, I had it as Exhibit 9. I'm sorry, can I show you what it looks like?
Oh, yeah, that's the page I'm on.
Oh, yes, yeah.
54.
Gotcha.
Okay.
Oh, yeah.
This drawing is showing how I would like to take the building down in size. The purple and orange lines are my roof drains from my own building. And currently still have that right now. I run it down into my own yard and drain it out into the yard. When I'm talking about water drainage off this, on that 66 feet, I'm not draining my building, I'm draining his hillside, which is running into me down and around that side hill. That has nothing to do with my building giving him or giving water to that roadway. And the driveway would be just wide enough that measurement would not mess with the drain field. And in that drawing, right on the end of that yellow line, you can see there's a 24-inch manhole there that it just bubbles out of. It's a water.
That little dot, that's what that is. That's the septic.
No, that's.
Or what-
That's a
there's no
drain. That's,
septic.
Oh, it's just a drain.
just water
Okay.
drain.
The
Yeah.
root water rain drains down there through a culvert and then just bubbles out because and it's not showing.
Yeah.
There's under the road, it's right there across the field. So I'm not proposing to give my problems to them. I'm just trying to divert their problems from their hillside to me. In the purchase of this land, I propose to purchase the property to the north side of this building. I never even asked to purchase this east 66 feet because I had explained I didn't have the abstract until the building was almost done, did not see that. So I was wishing to build to the north of my house. Had no knowledge of building over their property. I was, in a time crunch, but I did not ask to buy that east 66 feet, had no intentions of that.
So with the concerns of the other party and your road being, or your new driveway being closer to the property line, is there a reason it couldn't be 8 feet?
Okay, so with that big trailer, you need to pull up and come around the curve to get into that shed to back up in there. My response to that, without being a jerk, is they haven't even applied for a variance to divide this property off from the original platted subdivision that their mom put out in 89 is when it was accepted. And your rules clearly stated this was a problem from 1970 on. This was how we're going to handle these problems. Penalties and all. Negligence doesn't count for somebody else's problem where they didn't know that they had to apply for a variance to divide that property off. He talked about the building and I could use their road. He forgot to tell you, this is an extortion. He wants $7,500 a year payment from me to them to use this property. And he can back out of it at any time he wishes. So if he backs out and I don't have a driveway, I can't get my business up there. So I'm just coming asking for the whole thing, and I'm just going to say, you guys have your thing. Didn't build on their property with any intentions or knowledge of it. I had explained I had called out through my bank to get a abstract remade. I have the letter and the copy of it. It didn't come till July 23rd. I have,
When did it come? When, with the letter?
It
was a
came
year
from
after you built
Novotny's
it?
law office in Chatfield. He had come down and done the research, but I didn't get the letter till July 23rd of 2019.
Okay, yeah, after, the year after.
No, it
Oh,
would have been 1 month before I was,
Oh.
the shed was up.
Okay, yeah, that's what I mean, yeah.
Yep.
Yeah, okay, okay. All right.
And Mr. Kaler had stated the phone calls. I've got my phone records with me, even if you'd like. A second, let me get to the right page. May I get my other packet, please?
Okay.
Phone calls on talking about buying the northern property.
Mhm.
November 2nd of 2018 at 8:02 a.m., 6-minute call explaining what I'd like to buy. November 30th of 2018 at 7:53 a.m., a 9-minute call explaining what he wanted me to pay for that property to the north. At that same time, we talked about extending this lot to the north. Now, when I say to the north, this line here never appeared until 2021 to 22 tax season. That's when they came down to the county and said that they owned the property, and that's when that line went on. So if you guys want to go back and kind of see from 2000 to 2021, it was always without that line. It never showed that as a separate parcel. On 12/27 of 2018, I tried to call Mr. Kaler again at 11 or 10:38 in the morning. It shows a 1-minute call, which tells me it was a no answer. On 12/27 of 2018 at 1:09 p.m., he called me back. We talked for 3 minutes about extending that lot to the north. Never again talking about these 66 feet. At that time, he gave me a price that I couldn't. I mean, he wanted more for that than the whole building was going to cost, so I couldn't do it. The reason for the LP tank set back to the north, it's my guy that sells me LP, they're out of Rochester, Country Propane. He says, our code states that you must be a distance from your shed.
I think it's
8 to 10, he wants, and he said, I'll fill that, or here in this one, you can see it, the tank sits right here, and the electrical meter's right behind it. He said, I'll leave it because it's in this problem. We were just gonna move it out to the outside edge of that wall, but I said, there's no need to move it because we don't know where we're gonna go. So this isn't a hardship for me. It's me trying to save as much of my real estate inside the building so I can keep my business assets there so I can finish my career out. I was given this under the Winona County's planning and zoning. I had a permit and a completion certificate. So I didn't try to do it hide it from anybody. The only hiding was done is that these 66 feet wasn't spelled out and asked for a variance. And even if he wants a road there, he's gonna have to apply for a variance. You can't just put a road up through there. It's zoned as residential, so.
Okay.
And then as far as the precedence goes, how far are they, are they gonna make sure this doesn't happen again? Negligence, you get fined for it. So
Yeah, there's consequences. Thank
thank you.
you, Noble. Is there anyone else who wishes to address? If not, I'll entertain a motion. You'll have to make it, the applicant has a little bit more leeway to address the issue. But if you want to come up and make it short,
Okay, mine is real short.
okay.
One in August 14th, 2000, the property was sold to Rick and Denise Boyum, with the exception of that 66 feet. In the process of our court trial, it was pointed out that they had access or should have read the deed 6 to 7 times. And so the bottom line is, this property is my property. The court has ruled it as my property. I guess it's up to you guys to determine if you're going to overturn the court ruling.
Okay, thank you. I think I entertain a motion to close the public meeting.
I would make a motion to close the public hearing.
Is there a second?
Second,
Discussion, the issue is that the board members do have a right to ask questions of anyone involved. So all those in favor say aye.
aye.
Those opposed say nay. The meeting is closed to the public and open to the board members. The only thing I would say is our only purpose here is to determine the 1 foot setback.
Yeah.
the
Not
variance.
ownership of the land.
The driveway is not pertinent. There are apparently no setbacks or from the neighbor's property. I assume you have all read the conditions, and we've read the opposition issues, the staff reports, and their take on it. I will state one thing is that every variance, every decision by the Board of Adjustment does not set a precedent, and other decisions does not set a precedent for any particular Board of Adjustment meeting. Every petition is separate and has no bearing on any other or
Thank
from
you.
a previous.
I wanted to clarify that as well.
Well, any issue with, that's been decided by the court.
Yeah.
So Mr. Kaler owns the 66 feet land there, and he can do whatever he wants with it within the current plans and zoning.
Yeah, I don't,
One of the questions that I forgot to ask, but you mentioned the landscaping on the part where the building's being removed. It's not really a part of the variance, but I'm assuming that, Mr. Salisbury, are you responsible for like putting that kind of back and working with like a landscape company or something to,
It says it in the court paperwork that I've put it back, but it also talks about with drainage and approvals of county and local codes and ordinances too.
That's addressed, okay. Is, but I'll assume then it'd be, the part of the building will be a concrete wall that you can put the slope right up to.
Yes, yep, just like the rest of it is, it's concrete wall that I buried right up to it.
Right up against.
Yep.
Yep. And I guess actually if there was some kind of a private driver there, regardless, it does have to have a ditch. Regardless, I mean, off of your property, a road would require a ditch, a drainage ditch with water
What, yep,
and the water coming down the hill from not your property, you have a right not to have that come onto your land.
or at least have a way to shed it around.
Right, shed it around it.
You know,
so-
I mean, it's natural lay of the land. I'm not arguing that, but they can't put it back and then just dam up the water at our building either. So we'll contour it to drain down this, to the ditch like has been.
And that's in the court agreement?
It says to applicable codes and standards but irregardless of how I do it, I have to follow Winona County's planning and zoning watershed ordinances, irregardless of whatever the court said too.
Yeah.
So I have to be in compliant with both.
Okay, thank you.
thanks.
Is there any other discussion? I mean, the findings are, I mean, it's stated they're pretty blunt, but they are always subjective because different people look at them different ways. So
yeah.
I would interpret, if I was on one side, I would interpret it to my best advantage, either ones.
Yeah.
It's, I guess one thing is the commercial building part and the size of it. But if you're allowed to do that and you're not, it's not a business from your home where people are coming to like a welding shop or something.
Yeah, that wasn't
That's
a
another-
question for me,
Yeah,
really.
right, yeah.
I don't see that 66 feet being able to become a road. So it seems like it could only ever be a driveway.
Access for the fields
Yeah.
or, yeah, access to the land, which is fine.
Are you like saying that, in terms of the setback issue of the foot?
Well,
Where
yeah,
if, like, the other gentleman was worried about having to get a variance for that if he put a driveway or a road
That's,
there? Is that
yeah,
what you're
but
saying?
that's not, yeah, but that's not relevant because,
No,
yeah,
no,
I mean, as far as, right.
yeah.
I mean, I'm just saying,
The
being it
66
was
feet can
never
be used for
platted as a
anything. Yeah,
road,
it doesn't exist as a,
it's not a
it's
road,
just a parcel of land
yeah. And I don't see any
that you could
future
build a
use for that
storage
other than a,
access.
yeah.
So do you have any other discussions or this, I mean, the situation is not ideal no matter how you look at it.
No, and it's clear that mistakes were made from both parties
Yeah.
involved here.
And, but it, I mean, and it is a fairly harsh penalty to have to tear your building apart, and it won't be cheap. So there is a penalty there for sure, which is not our purpose. So if I would entertain a motion, one way or the other. Personally, I would, well, I won't say.
You don't get to say.
Well, you could make a motion
Yeah,
as
you
well,
can make a
right?
Okay, well, I'll make a motion that, actually the best remediation for both parties is that we grant the variance. Is there a second? But the agreement is, I mean, it's not having a variance to
Right.
leave the shed there. He
Right.
has to stay a foot away from the property. And once he's a foot away from it, with the variances, they want to be 8 feet away.
Mhm.
Okay, so the access, according to current rules, will never be used for a housing development and back.
Mhm.
So that land is useless, so requiring 8 feet is, that's the rule, but variances are meant to help people
Right,
accommodate and fix situations.
well, and being that he has to take it down,
Yeah, that's,
you know, it's,
you want a second it, Kelsey?
well, I'm still just kind of curious
Yeah, I'm
about the
still working on
driveway.
it, too.
Okay, that's fine, there's no,
Because
no.
there's not really any.
You've read that, yeah, I
I mean, I
yeah.
know they don't need a setback, but I'm curious because if they have a new driveway put in,
Mhm.
is there anything from their township? I don't remember reading that much about
This one.
a new
Eric, do
driveway
they need a permit from the township to put a driveway in,
to,
move it?
Each
I mean,
town,
not move
yeah.
it, put in another one.
In this case, the St. Charles Township Board would have that discretion. Each township acts a little bit different, but yes, they do like to look at driveways, to look at drainage, to weigh in on a culvert if that is necessary. So I guess we would leave it to the Township Board to discern.
They do
Whether-
have to give him access to.
I
his
think he
property,
does,
right?
yeah, I think they don't
Yeah.
have a choice, really.
it would just be a matter of if it needs a culvert or where it is
Yeah, they can.
and, okay.
What would, are there more potential uses for the 66-foot parcel other than a driveway? Is it possible to put a structure on that? Other than a dwelling?
Hypothetically, yeah, it just depends on size, scale, and use. And I think in the documents that we received, they said they were using it for tractor traffic to take hay mowers and hay binds through and make a hay crop. And there's something about hunting or recreational or something
So
too.
my question is, I guess, if they were to put a shed or something on that 66-foot parcel, would a variance like this affect their ability to build anything there other than them following the setbacks on their side?
No.
Okay.
Yep.
And I'll second your motion.
Okay, the motion has been made and seconded to grant the variance. The petition as written here. Is there more discussion? Questions? If not, I will call for a vote. All those in favor of granting this petition as written and talked about with the conditions, say aye.
Aye.
Aye. All those opposed say nay. The variance is granted. And I will read as soon as I find it, because there is recourse. All decisions by the Board of Adjustment in granting variances or in hearing appeals from any administrative order, requirement, decision, or determination shall be final, except that any aggrieved person or persons or any department, board, or commission of the jurisdiction or of the state shall have the right to appeal within 30 days after receipt of the notice of the decision to the district court in the county in which the land is located on the questions of law and fact. Any party that would like to submit an appeal to the decision rendered at the public hearing must do so to the district court. Planning and Environmental Services is not responsible for filing the appeal or obtaining representation by counsel for the petitioner. The next agenda item is, as soon as I find it, docket number BOA 41824, number 2. To consider the petition of Jay and Laura Grund, applicants, and Carl and Judith Ridderly, landowners, regarding the following: consideration of a variance to allow a new residential development in urban residential zoning district on steep slopes of Mississippi River Bluff, natural features overlay district pursuant to chapter 11 of Winona County zoning ordinance, amended to include the findings of fact on page 84. And go ahead.
Good afternoon.
And just one thing, thank everyone else on the other petition for participation and answers and presentation. Okay.
So a little overview of the site itself. As Bob mentioned, we do have the petitioners here today, so they are potential purchasers of the property, and the current owners are online as well. So a bit of an overview. It is in Richmond Township, Section 17. It's located along Mary's Hillview Drive, and it is within a platted subdivision. You can see in the map, the larger image, it is towards the end of the cul-de-sac there. And there's similar residential development along the roads off of 61 there. This is the platted Marysville subdivision number 2. You can see the parcel in question is the furthest south on the west side of Hillview Drive. So these next couple of slides are going to be talking about the site plan. After the site visit, we did propose changes to it. So originally when it was submitted, it was an 100 by 100 footprint. This is what the applicants had proposed. And then this is what staff created on the right, so showing the 100 by 100 building site. On the left there, you can see some of the natural features that we're working with. Shoreland does intersect the parcel on the western side of it. Most of it's covered in bluffs and steep slopes. And then we do have a road setback to work with as well. So after our site visit, we did go out to the site, me and another planner with our office, as well as the resource conservationist from Soil and Water. We are recommending as a condition that the building footprint be contained in this figure 2 here, which is in the staff report. But essentially it's constraining the site to stay away from, there's 2 active gullies. So there'd be a 30-foot buffer on each side of those to protect that development and protect that erosion and soil around those. So some of the considerations I've touched on already. There are some pretty steep slopes on the property itself. It is about 2.5 acres. It is split zoned. The building site, you can see on this image, it's urban residential in the yellow, and then the southeast corner is actually ag resource conservation, but the building site itself would be within our urban residential zoning district. It is proposed on the flattest area of the property. It would be a single family residence that they're really proposing to try to keep up closer to the road and off of the steeper slopes. We do have some concerns about the potential erosion and stormwater runoff impacts caused by the development in this area. So if this variance were to be approved, as well as the conditional use permit from Planning Commission, we would be working with petitioners on a soil erosion control plan and working with Soil and Water Conservation District to make sure that there are enough best management practices implemented in order to make sure that the site itself is protected. These are some photos from out on the site. These first two here are off of the roadway. The driveway stakes are circled in red. This is looking up towards the cul-de-sac. This is the other way down the drive, still looking at that driveway access. This is getting into the site itself, so it's looking southwest, up at the flatter area of the building site. And this is down on one of the steeper corners, looking back up. And these are all referenced with the images on the left, which is still showing that 100 by 100 footprint, whereas staff would be proposing a smaller footprint that would really be incorporating this flatter area on the site.
So those stakes, that stake is indicating the corner of that 100 by 100?
Correct. Yep. So this is the stake on the southwest side. It's showing the gully there in the larger image. So this would be the 30-foot buffer that we're proposing, is to stay away from the top of that gully. And then in this photo here, you can kind of see the flatter area as you're looking up towards the right. So we just try to get some photos of the two gullies, the southern side and the northern side. When you're looking at the aerial, I'll show you. If you look at the contours, you can see how both of these gullies run and kind of border the building site
Oh, yeah, both sides.
there. Then it might be a little bit difficult to see in these photos just with the lighting, but you can kind of see how the land slopes down and then curves around in both of those. So as far as the township acknowledgement, Richmond did support granting the request. They submitted that at the end of March. So our recommendation would be that you consider all materials and testimony before making findings that support your decision. We did draft our analysis and findings to support granting the variance with the four conditions for your consideration.
Okay, does anyone have questions for Olivia? Okay, thank you.
Thank you.
And is the applicant or someone here to represent them wish to come forward and address the petition, your petition? State your name and the address for the record.
My name is Jay Grund. I live at 409 Skyline Drive in Trophy Club, Texas.
Okay.
First of all, thanks for the opportunity to discuss this. My wife and I, as I stated, currently live in Texas and have a contract to purchase the parcel in question. A contingency within that contract allows us a due diligence period to determine the feasibility to build kind of a home on the property. Our intention, as was stated by Ms. Luther there, our intention is to build a single-family residence on the lot at some time in the near future, probably within 5 years. Because we're still conducting our due diligence on the property, we haven't commissioned a detailed architectural plan. We don't have, an exact idea of what we would build there. And that's why we proposed 100 by 100 build site initially, to be able to give us some flexibility to take best advantage of the lot. Our plan would be to build a home that would be in harmony with the land and the neighborhood, as well as to preserve as much of the natural landscape as possible. I just, again, I think that the value of the land is of the location and the beauty that have potential there. Certainly, any restrictions that are put on either us or the current owners moving forward would vastly affect the property or what could be done from an ownership standpoint or a builder standpoint. So I thank you for your consideration, and I look forward to making Winona County our future home again.
Okay,
Thank you.
just wait a second to see if you have any questions, either Kelsey or Jordan. Okay, I guess not. Thank you,
Thank you.
Jay. All right, I guess then we'd entertain a motion to open it to the public.
I'm so moved.
Okay, and
Second,
okay, the motion is made by Jordan and seconded by Kelly to open the meeting to the public. All those in favor say aye. Aye. The meeting is open to the public. Is there anyone else who wishes to address the petition before the board at this point? Petition number 2. For the second time, is there anyone who wishes to address the board concerning this petition before the board at this time? For the third and final time, is there anyone who wishes to address this petition before the board? If not, I entertain a motion to close the meeting.
Moved.
Okay. Kelsey?
Second.
Okay, the motion's been made by Jordan and seconded by Kelsey to close the public meeting. All those in favor say aye.
Aye.
Those opposed say nay. The meeting is closed to the public and open to the board. Did everyone see the letter from the property owners below the land? I think it came in later, I don't know, I had it. I think that's the amended part.
It's in here, or at least it was.
There was, I saw it somewhere. It was in the pack, the electronic packet. But at any rate, it was concerned about, and this is, I mean, does not affect this lot as it now exists. There's an existing problem with the water coming down up here or eroding the neighbors, which is a separate issue. But
Yep, there's a letter in your packet that we did have, we received email and they did follow up. They were just concerned. There has been some issues with runoff and drainage and because of the terrain associated with that area. And I think there was a video clip, if you got an opportunity to see that, it showed an extreme rain event where the water really pooled up, and the pictures that they submitted were showing what a neighbor had to do to kind of address a lot, excessive runoff coming down the street and off of that subdivision. So it is a concern, and therefore that's why there is, as Olivia pointed out, there is a conditional use permit process tonight that's going to look at a lot of the siting and conditions and erosion control that would be instrumental in approving this request as well. So.
with this, is that the township's responsibility to, not erode the neighbor's land, so they have to put rock and cement in?
It's within the right of way of a street. It falls under the township, but if you're building or if you're putting driveways in, individual property owners have an obligation not to accelerate runoff too, so.
Yes, okay. Thank you, Eric. Does anybody have, I guess, I was just gonna say that in regard to that, I would, and maybe that's already included in the condition, but I would make it that no water from this lot can enter that ditch. It has to be dealt with other ways. If the building, yeah,
What do you
and it
mean?
looks like it's cut through the hill already, so it probably wouldn't be a problem, but on one of the slides, it showed the road where she had it staked, and there's a bank on that side, so access to the lot looks like they have to do some moving anyhow.
Yeah.
So the variance, our essential variance is to allow this on the slopes. Is that correct? And that's what our job is, to let on the steeper slopes. Is that right, Eric? Essentially, that's our.
I know in their thing, they said they hadn't done a septic system assessment yet, but the 100 by 100, that's just the size of the house, right? That's not the parcel that they have to work with, so the septic system has to fall within that.
So we would be proposing that smaller footprint, which is what Soil and Water provided to us that was shown. So it's not the square, essentially. It'd be a small area that has a buffer from both of those gullies. They haven't had a septic designer out on site yet, so it's really going to be up to where they can find the best placement for that septic system. It does take priority on the site, so really what soils are going to determine what type of system and where it can be placed.
But would it fall within that soil and water conservation and your guys's little red, yellow bubble? It would have to be in there, or is that just for the building?
That would be for the structure if they can site the septic and well outside of that and still have it meet code,
Okay.
then that would be okay. But if it can't, then it would need to be within that area.
And is that something that's probably would get bounced back to us to approve potentially if it needs
I
some
don't
kind
think so,
of
but Olivia knows.
due to the circumstances of the area to where it would make more sense to wait to have that assessment done, or? Sorry, is my question.
So
Kind of a catch 22 because, yeah, they can't.
Because
Yeah,
they wouldn't want to build the house if they can't put in a proper septic, right?
they won't, yeah.
And so does it make more sense to have that assessment first along with the building, or to know that it's all a go? Or will the septic system, being that we've approved the building, then be like, oh,
Actually, we haven't approved the building. We're-
right, but I'm just
I mean,
saying,
we're
if-
allowing it on this, yeah,
Right.
on this slope, and so,
Right.
yeah, and then the planning commission and others have to.
right, so you'd be providing relief from the steep slope standards
Okay.
for development.
Essentially.
Okay.
Any other questions, Olivia? Okay, thank you.
You're welcome.
One big concern I had is I noticed on the picture, there was a shagbark hickory on the side there, and these are extremely valuable trees that are rarely grow. I'm just kidding. We have a lot of shagbark hickories. I like trees. Yeah, yeah, I'm just comic relief here. Okay. I think it makes sense to, even though it is there, the subdivision or is there, the land is, it's a good way to use land that is not useful for any other thing, and the lot exists.
Yeah, it
It
is.
wouldn't destroy a lot of woods or anything. And I'm sure they, well, I mean, just for the beauty of the lot, maintain as much of it as they can in a natural state and meet the drainage issues. And I guess it's not, Eric, is it appropriate to put anything in there about, I guess we don't have that purview, do we, about drainage? Other than to note that I'm concerned about it not going onto the road ditch and adding to the other side. Or is that the planning commissions or the zoning?
Kind of, yes, it's part of the planning commission as far as the conditional use permit, but it's also part of your recommendation. It can be because we would, as they would hypothetically, if this was approved and they'd be gearing up to submit their zoning permit for construction, those are the paramount aspects that we would really want to take a look at
Yeah.
prior to issuing a zoning permit.
With the slope, it would be appropriate. Well, I would, okay, go ahead, George.
Yeah, from looking at it yesterday, I drove by and
Oh,
it seems like from what I saw that everything would be going away from
yes,
the
I
road at
think
that
so. So it maybe not,
point.
a
then-
done deal. Yeah,
Yeah, I think the rest of my concerns with erosion and water would be covered by the stormwater management plan here.
yeah,
There's plenty of lots this difficult in the county that have been developed already.
right, yeah.
And I think these type of measures really take care of a lot of the issues we have with that.
Yeah,
Well, it doesn't seem like the driveway would be as difficult as some of the ones that we've.
yeah, right, it should
Seems
be.
closer
it's
to the
pretty
road
much
at
like
least.
straight
Yeah,
in,
yeah, it must be,
Yeah.
there, yeah. And it was the bank that showed there, was that further down the hill or right in front of the lot? Is it, was the
That
road kind of,
little,
there was a little berm?
yeah, that was right in front.
Okay, yeah, and that's just, okay. Well, does anyone wish to make a motion?
Yeah, I would make a motion to approve,
And the
this-
conditions were,
yeah, as written, with
Page
the,
86.
with the conditions.
I'll second.
okay. Motion's been made by Jordan and seconded by Kelsey to approve the petition with the conditions as written. Is there any more discussion? Questions, concerns from the board? If not, I'll call for a vote. All those in favor of the petition as written with the conditions, say aye.
Aye.
Aye. Those opposed, say nay. The petition is granted. And I will read. Here it is. The appeal to district court. All decisions by the Board of Adjustment in granting variances or in hearing appeals from any administrative order, requirement, decision, or determination shall be final, except that any aggrieved person or persons or any department, board, or commission of the jurisdiction of the state shall have the right to appeal within 30 days after receipt of the notice of the decision to the district court in the county in which the land is located on questions of law and fact. Any party that would like to submit an appeal to the decision rendered at the public hearing must do so to the district court. Planning and Environmental Services is not responsible for filing the appeal or obtaining representation by counsel for the petitioner. And the next item on the agenda is adjourning.
We'll make a motion to adjourn.
Okay, Jordan has made. Is there a second?
Second.
Okay, all those in favor say aye. All those opposed say nay. Nay. Just for the record,